This is a panel on prosecutorial and defender independence. That the independence of both seem to be under a greater threat right now than we've seen almost in any time in the last several decades. And I'm going to start, Andrew, I'm starting with you, since you got the ball, you got the ball rolling as in a way that shocked a lot of us. And I wonder, well, would you tell us what happened? And I know it's not, I know Governor DeSantis wasn't after you because you spent too much time at Disney World, but he did come after you.
Good morning. Yeah, they're going to put that on my epitaph. He started the trend of prosecutors getting suspended. So we could spend a long time talking about this, but I'll try to answer the question briefly. In short, I was suspended because I presented a different vision of how criminal justice should work in my community. Because the voters in Hillsborough County, Florida, where Tampa is, agreed with that vision. Because I did my job in the way that I told voters I would. Because we succeeded. Because I was perceived as a political threat. Because I spoke out for issues that affect the criminal justice system. Because I stood up against discrimination that was happening in our country. Because I stood up for a woman's right to choose. Because I exercised my constitutional rights. So I was suspended. But the better question is not what happened to me, but what happened to the state of Florida. Because my suspension is not about me. And it's not about my position as the state attorney. And I am, for the record, still the duly elected state attorney in Hillsborough County. There's not been one from office. But this is really about democracy. This is about the fact that you have, in my case, and this has been now adjudicated by a federal judge, a governor who broke state and federal law by suspending me for political reasons. A governor who broke state and federal law to suspend me for publicity. A governor who broke state and federal laws so that he could use this as a talking point in a stump speech to finish fourth in New Hampshire, I guess. But what's really scary about this is that it has disenfranchised voters. It has chilled people's willingness to run for office, mine included. It has taken the rights away from people in my county to have an elected official of their choice. It has chilled people's free speech. And most importantly, it is a direct attack on the rule of law, because even after a federal court found that the judge broke the law and called on the governor to do the right thing, and we won't get into why the judge felt like he couldn't do the right thing after finding that there was a violation of federal and state law, but even after calling on the governor to do the right thing and to reinstate me, which would be following the law and upholding the law, the governor declined to do so. And I'll end with this, Steve. I've had so many people over the last year say, well, he can't do this, and they can't do this, and this shouldn't be. Those words matter in a law school classroom. They don't matter in the real world. The law is only as powerful as people's willingness to enforce it. Yes. And when people don't enforce the law, and when courts do not enforce the law and remedy violations of the law, then the law has no meaning.
And let me just ask one follow-up. It's not just that you were removed. Would you tell them how that occurred?
Sure. So the day was intentional by the governor. And I think it was intentional because as a criminal justice reformer, and we can debate what that means, but as someone who had a slightly different idea of how prosecutors should do their jobs, it was a day that sort of epitomized that approach and that philosophy. We had, in my office, set up a conviction review unit, which I know everyone in the room knows what it is. We had worked with the Innocence Project on a case where a man had been wrongfully convicted and imprisoned for 37 years, spent time on death row for rape and murder that he did not commit. Our conviction review unit demonstrably proved his innocence. He was released from prison. Then the work that we did in our CRU started working with law enforcement to investigate the actual rapist and murderer, identified 2 men that had committed that horrific crime from 1983, determined that they'd also committed another crime from the same period in 1983 that had never gone solved. And I was supervising the indictment and in the grand jury that morning of 2 39-year-old cold cases, of 2 heinous rapes and murders, of 2 innocent women in our community whose families had been denied justice for nearly 4 decades. And we were preparing to make the announcement that afternoon, expecting that the indictments would be returned. That was what I was doing when I was told that I was suspended from my job for supposedly not doing my job.
So fortunately, when things like this happen, a lot of lawyers stand up for justice. And they stood up for Andrew. We've given Andrew an award that represents the courage that he displayed. And sitting next to me, Sarah, is representing another Florida prosecutor who got removed, and she's going to tell you about that case without crossing a line that she can't cross, because she is, in fact, representing this former prosecutor, or I guess current prosecutor, who's just not prosecuting.
Thanks, Steve. So I'm Sarah Alpert-Lawson, and Steve mentioned talking about lawyers standing up, and it's an honor for me to be here with you all today, because this is, I know many of you have been working in the trenches on these issues for a very long time. I first got involved in this issue of defending prosecutors' independence and discretion the day Andrew got suspended. Until about 2 months ago, I'm a partner in the Baltimore and Tampa offices of Zuckerman Spader, and I was a Tampa resident. Andrew was my state's attorney. And the day that he got suspended, I still just remember the shock that I felt, because as you know, we all know and have experienced in communities where there has been political tension between the reform prosecutors who have now gotten elected in places around the country with law enforcement and others who disagree with their policies, and it all felt very political. But that moment felt beyond that. It's not partisan. It's the foundation of our democracy, and it seemed like if somebody can come in and now remove an elected official because of partisan differences, what do elections mean? What do they mean anymore? And so I immediately, knowing my partner, Sandy Weinberg, knew Andrew well, raised my hand and said, how can I help? How can I get involved? And so I worked on with Andrew's team on an amicus brief in his case. I worked on an amicus brief in the case in Georgia after Senate Bill 92 was passed this year, which has now gone into effect. And then things in Florida felt like they got worse because it escalated with Monique's case. So almost a year to the day that Andrew got suspended, Governor DeSantis issued a 40-page suspension order suspending Monique Worwell, the state attorney for the 9th Judicial Circuit, clearly and solely because he just had policy disagreements with her. He pointed to nothing, absolutely nothing that she did wrong. Essentially, the allegations in the executive order are that she soft on crime, and she allegedly authorized policies or practices, which he pointed to no specific policy or practice. He pointed to no specific thing Monique said or did, and simply said she didn't get, there's not enough mandatory minimum sentences coming out of her district. But you know what? He didn't even point to anything that would reliably indicate that that was actually true, because he then causally connected that to prison admission data and said, well, she's towards the last on prison admissions for certain categories of crime, so she's not charging enough mandatory minimums. And it went on, claiming that she was not charging enough drug trafficking, that her juvenile case processing times, which somehow she's solely responsible for how quickly juvenile cases move to the system. You know, anybody who's involved in this knows that that makes no sense. That those were too slow, and so therefore she neglected her duty and was incompetent. And what's shocking, what's more shocking about this order is now essentially, if he can get away with suspending somebody on such vague grounds, what does it mean anymore for elections? We're currently challenging the executive order in the Florida Supreme Court, which is the procedure under the Florida Constitution, seek a writ of quo warranto and mandamus. The Florida Supreme Court, however's precedent is that their review of these issues is very limited. Essentially, if you state a ground and it reasonably relates to what could be neglect of duty or incompetence, they'll uphold the order, and then you go to a trial in the Senate to determine whether removal or reinstatement. So we're in the process of that right now. Monique's, has been a courageous leader in her office, and and continues to be courageous. And I want to recognize Monique, who is here today, because what she has done throughout her career is continually fight for criminal and racial injustice. And if we don't acknowledge that all of this is a reaction to holding traditional power structures to account, and a reaction to the demand for transparency, the demand for racial justice, the demand for economic justice, we don't recognize that that's what this is a reaction to, we're missing the boat. But the scary thing is, what's good for the goose is good for the gander, because once those democratic processes are gone, they're gone for everybody on all sides. And Monique has fought for this her entire career. So Monique, would you? And so these actions, and I can tell you in Florida, they are having a chilling effect. They are having the intended effect. Lisa talked about the overcharging of defendants. Well, let me tell you right now, in Florida, you sure as heck everyone's going to be overcharged, because now the expectation is you better be getting those mandatory minimums. You better be sending people to prison. You better be getting those criminal history, felony possession points. Everything that you can bring, you're going to bring, and the prosecutors are not going to negotiate anymore. They're not going to. They're not going to exercise their discretion. So it's going to get worse. And this is spreading like wildfire throughout the country. And so there is so much work to be done, and it's so encouraged that there's so many people here in this room who are working towards making the public aware, and we have to, as the ABA, make the public aware of the stakes of this issue. So, I'm sorry, I probably talked too much.
No. One fast question.
Yeah.
Did you just have an amicus brief filed against you by some heavy hitters?
Oh, yes. Yeah, yes. Thank you, Steve, for bringing that up yesterday in Monique's case. Bill Barr, Edwin Meese, Michael Casey just filed an amicus brief. It was, and I can't probably not be too biased right now, but it was a diatribe against reform prosecution and that's being soft on crime and making communities less safe, and arguing that, anyone who enacts such policies is neglecting their duty and incompetent and should be suspended. And to have folks like that come in and stand up and say those things, it makes it even more important that we have an equally strong, unified response as to why that is so wrong on so many levels. And so, this is just going to continue.
So for those who are younger in the room, the three men she mentioned are former attorneys general of the United States who once took an oath to do justice. The problem of independence is not confined to prosecutors. Keisha, would you talk about the problem from the point of view of defenders? And I understand another one bit the dust in Pennsylvania just recently.
Just last week. Good morning, everyone. So to kind of set the stage for Pennsylvania, my lovely Commonwealth, Pennsylvania has 67 counties. And outside of Philadelphia, the Defender Association of Philadelphia, the office that I lead, those 66 public defender offices are all part of county government. Pennsylvania is the only state, we're the only one left that does not provide a single penny from the state legislature to fund public defense. And so again, outside of Philadelphia, all the public defender offices are funded by their county. They're considered part of their county structure. A lot of the resources that one would think should be held within the public defender's office really serve the interests of the entire county, including who makes the decision regarding hiring, budget, anything human resources related is outside of that public defender office's control. Montgomery County, I was the deputy chief defender in Montgomery County. I got there, I left the federal defender's office, the capital habeas unit, and got to Montgomery County in 2016. And I was recruited directly by the then entering chief defender, Dean Beer. And we knew that we had an uphill battle in Montgomery County because for 134 years, the county had been exclusively under Republican control. It was a very conservative county. The public defender office was incredibly under-resourced. By comparison, the prosecution's office was funded at $20 million per year. The Department of Probation was funded at $10 million per year, and the public defender office was just under $5 million per year when we started. We were not surprised we were fired because we were told at the very outset that we serve at the pleasure of the county commissioners. Those were the exact words that were used. And they wanted us to run every decision by them, decisions that are firmly in the purview of public defense. And there were certain decisions that we made where we did not do that because we didn't think we should. Our clients come first. That is our duty. We are zealous advocates. And we had been working with the ACLU of Pennsylvania for some time on a number of issues, including probation reform and bail reform. We would never invite the ACLU or other stakeholders or partners into the county. I would meet them at a diner called Michael's Diner in Philadelphia, sitting in a back room over coffee and talking to the head of the ACLU on a number of issues, providing information, data, our statistics, caseloads, what our clients were experiencing on bail, probation. We had about a 4-year working relationship where we were working with them to really do the work that, the systemic reform that we needed to happen in Montgomery County, unbeknownst to the county commissioners, because we knew the moment they knew about that partnership that both of us would be gone. In the fall of 2019, the ACLU approached us. They were suing Philadelphia for Philadelphia's bail practices, and they knew that Philadelphia had nothing compared to Montgomery County. And they wanted amicus brief from Montgomery County describing our bail practices and what our clients experienced in pretrial detention. And in Montgomery County at that time, it was very routine for people accused of the most minor crimes to be held on significant bail. We had clients, the client at the center of the amicus brief that we filed was a recent mother who had $50,000 bail set on her for a retail theft of an item that was less than $50. In custody for several months, no way to express her breast milk, and it was a bail fund from Philadelphia that actually came in, despite our efforts in the public defender's office, to get her released several months after being detained. And so we filed that amicus brief, and the expectations of Montgomery County at that time was that everything had to be collaborative. And so the minute that we filed that amicus brief, that same day, we got a call from the president judge who wanted to know why we filed an amicus brief without consulting him. He had not had an opportunity to review the brief. Then we got a call the next day from the county commissioners, the chief operating officer of the county, to ask why, again, we had not shared the amicus brief so that they could review it. We knew filing it that this would bring attention to the county, and asked us directly, the president judge and the commissioners asked us to withdraw the brief. It was left unsaid what would happen if we did not withdraw the brief, but we knew what would happen if we did not withdraw the brief. I had a conversation with Dean Beer that same day and told him we are not withdrawing the brief because whether we withdraw the brief or not, we're going to get fired, so we might as well just let the brief be filed. But you know, that was Dean's call, and several meetings occurred again in that mid to late February after 2020, after we'd filed the brief. Another meeting with the president judge and Dean Beer, and there were threats of filing a disciplinary bar complaint against Dean. There were threats of going to the county commissioners about our budget, again, if we did not withdraw the brief. We made the decision to withdraw the brief, and about a week later, Dean got a call. We are housed in the courthouse. Almost all public defender offices in Pennsylvania sit in their county courthouse. Our clients have to go through metal detectors and be searched to come and talk to us for routine matters, to go to court. And so we are sitting on the second floor of the Montgomery County Courthouse. Dean is called over to the county commissioner's office, and my phone starts ringing 5 minutes after the meeting starts. And I did not even answer the phone because I knew why he was calling and I knew what he was going to tell me had happened. Instead, I run around my office. I took off my heels. I ran around my entire office. I started calling for anybody who was in the office that day to please come to the conference room. I needed to meet with them immediately. And I started my meeting, and then one of our administrative assistants says, the county commissioners are looking for you. So then I knew that what was about to happen to me. Dean at this point was escorted back into our office by 2 sheriffs. This is 10 o'clock in the morning. He was then escorted. They stood over him while he packed a box of his personal effects, and then the 2 sheriffs escorted him out of the building to the parking lot, watched him get in his car, and made sure he drove out of the courthouse. I avoided that summons to meet with them for 15 minutes so that I could talk to the staff. Now everybody is now in tears, loudly, audibly crying, public defenders and investigators and social workers, asking what was going on. And I wanted to take a few minutes to calm down the staff and to give them reassurances, hugs, but I also told them at that point that I had a meeting that I had to go to because I couldn't avoid this meeting any longer, and that it is highly likely that I too would be fired. I had my meeting. It lasted just a couple minutes. We were told explicitly, it was confirmed in a letter. There's a lovely 3-page letter, which I will not read to anyone but can make it available, detailing all the things that we had done over 4 years leading up to the amicus brief. And these were all routine matters. In one instance, the county was overcharging our youth clients about 5 times the amount to make a call to their parents. And we pushed that issue in a way that they did not appreciate so that the cost of those phone calls could be lowered. The issues around probation, and of course then the issues around bail reform. I too was escorted by 2 sheriffs. This is now about 10:30 in the morning through the courthouse and into my car and watched me drive away. So that was Montgomery County. And just last week, the chief defender of Luzerne County was fired, Stephen Greenwald. He'd been the chief defender for about 10 years and was fired last week. Everyone knows what happened in March of 2020, so I won't relive all of our trauma of the start of the pandemic. But when I talk about what happened in Montgomery County to public defender agencies who want to do routine things, this is an amicus brief. It is the most boring thing on the planet. It's an amicus brief. Our withdrawing that brief brought more attention to the words amicus and what the word amicus means around the state and around the country than anybody had ever imagined. And everyone read the brief regardless of it being withdrawn. In 2022, the county commissioners did make a statement that they realized that they should really create an independent supervisory authority for the Montgomery County Public Defender's Office. And so now there's quasi-independence. That board just hired a new chief defender who's a former defender from the Philadelphia Defenders and is an amazing, excellent attorney. But I've already met with her about 3 times, and she feels the constraints that Dean and I felt, and is already feeling the pushback in terms of things that she wants to do, including hiring, including salaries, including having enough resources to do the work she needs to do, and has already expressed, whether or not she will be able to make the impact that she would like to make for the lawyers and in Montgomery County.
Well, Lisa talked, when she spoke about standing up against prosecutors, who would have thought you'd have to stand up against county commissioners as well as the defender? And thank goodness you had the courage to do it. So it brings us to Rosemary. The Brennan Center has been a force for law reform, for criminal justice reform, and we seem to be having something of a backlash here against anything that looks like reform. What's going on here?
Can't quite figure out how the mics work, but thank you for having me, and thank you for having this really important conversation in this room. I think that it was Sarah actually said it quite clearly, and also Andrew, about what is going on here, which is this is really a pushback and kind of a retrenchment of the forces of traditional law enforcement and stakeholders who are feeling that the ways that people like Andrew and Monique and others have been doing their job as prosecutors has really been, I think, threatening the concept of what they think a prosecutor should be doing. And I think Bill Barr et al. Are probably the classic example of that. I want to just sort of put this in a little bit of a broader context of what maybe people in this room can be thinking about what you could all be doing, and kind of having a conversation about what actually is the role of the prosecutor. Because I think a lot of this pushback, what DeSantis said about Andrew Warren, about Monique Worrell, I think the impeachment proceeding against Larry Krasner, all of that goes to this idea that these prosecutors are not doing their job, which is fundamentally a distortion of what the prosecutor's job is. And I think all of us in this room know that prosecutors have historically used their discretion It's just something that prosecutors do. They do it, and traditionally it's been, kind of, I guess, there are many who say that it's been used kind of to be more harsh. It's the, kind of discretion that allows a prosecutor to overcharge and therefore maybe force a plea. And that kind of exercise of discretion has not been challenged. It's kind of a given in our system because that's how the system has to work, because there are so many cases in the system. How else is the system honestly going to work if prosecutors don't have that discretion? So what now, has been happening is that prosecutors, these chief prosecutors are running on the idea that we can actually use our discretion differently. We can use that discretion and we can decide not to charge the highest case, maybe not even to charge a class of cases that our limited resources in our office are better spent, kind of investigating more complicated homicides and actually trying to clear those, as opposed to charging, low-level marijuana cases or whatever that category is. And the other difference is, and this kind of goes to the democratic accountability question, prosecutors' offices have traditionally exercised that discretion in, kind of without much daylight, in the office. Maybe the defender community, maybe there's like an unspoken understanding of, there are thresholds we use, we're not going to prosecute below that, we can sort of work that out. But the public generally doesn't really know how that office has been exercising their discretion. What district attorneys like Andrew Warren, Monique Worrell, and others have done is they've actually said, this is to the public, this is how we are exercising our discretion. And I think that really goes to that question of transparency and democratic accountability, because these are elected leaders. And maybe their communities have a right to know and decide for themselves. And the really interesting thing is that the vast majority of them have been overwhelmingly reelected because their communities understood what they were doing and actually liked that. And I think that those kind of issues about maybe explaining and, and this also I think goes to the role of the defender, like what actually is the role that these people play in our system, the really important role of prosecutors exercising their discretion in wise, evidence-based ways, defenders actually standing for the people that they represent as opposed to being a part of the system itself. I think also the other kind of aspect of it that kind of goes unsaid is there is this, well, it's explicitly said, and maybe we need to be challenging it more front on, is this idea that these prosecutors aren't doing their job because, and therefore their communities are not seen, which really, it flies in the face of evidence. I think Governor DeSantis said that about State Attorney Worrell, when actually the FBI statistics showed that the crime rates in her district were actually lower than national and other parts of Florida. And I think that also goes to what Barr, McCasey, Meese et al. Are talking about, kind of all of this woke prosecutors, or all rogue prosecutors, whatever you want to call them, are all kind of causing mayhem, because of their policies. And I think there's a lot that can be done, both with regard to education, data, research, and also just kind of this body talking more explicitly about how what they're doing is well within the role of the prosecutor.
So you've heard about tax on prosecutors, tax on defenders. It's not just governors and commissioners who are wielding the attack. Apparently there are a lot of people in the Georgia legislature were not happy with the Fulton County District Attorney, who was investigating a group of people she thought were trying to steal the Georgia election, including the former President of the United States. And so I asked Judge Donald if she would take a look and briefly tell you about legislation that was passed by the Georgia legislature and signed by the governor, and just briefly describe what that legislation does.
Well, Steve, for letting me know that. I kind of missed that assignment. Or should I say the dog ate my homework? So I haven't looked at that legislation, and I apologize. But I wanted to just talk about something else. Maybe Sydney will talk about that. But you know, this will be.
I got you, Judge Donna, I can talk about it.
Good, you can talk about your, because I want to, yeah, so I wanted to talk about something else, kind of generally. This has been really interesting, listening to the prosecutors and the defenders, and I've never been a prosecutor, but I was a defender, and so I stood opposite a number of prosecutors, and of course I've been a judge in the state and the federal system, and I wanted to go back to this, you know, the role of the prosecutor. The role of the prosecutor, and the prosecutor is supposed to act with diligence and promptness to investigate, litigate, and dispose of criminal charges consistent with the interests of justice and with due regard for fairness, accuracy, and the rights of the defendants, victims, and witnesses. And I think it's been said already, but I think it bears underscoring. And Monique, I just want to say, when Sarah was talking about this case, I mean, a lot of the stereotypes sort of entered into my mind, but this whole notion of consistent with the interests of justice, and what I see happening is that people are really redefining that word justice. It has taken on some definitions that have political implications. I mean, who decides what justice means? And is justice defined differently under different circumstances? And I think that's kind of dangerous, because when a legislative body or a governor or a commissioner decides that, in my view, the prosecutor's decision to do the job in a certain way does not equate to justice, and I'm going to superimpose my executive authority to recorrect that definition, that is dangerous. I told you all on many occasions that in different communities, there is not a shared definition of rule of law, and I'm speaking now to this obligation for transparency and fairness. People don't feel in certain communities that they can expect justice from the courts, and it's not just the courts, because people are supposed to be able to come in there and stand equally before the law. And I sat in those positions in various courts, and as charges were read, told people that the law applied equally to people standing before the courts. But what we're seeing is that maybe that's not true. That maybe that hasn't been true for a long time. And it causes people to come into these venues with a great deal of skepticism. What Andrew and others have described provides a real danger, I think, to what we call the system of justice, or the criminal legal system. Because, as Sarah said, and I think as Andrew said, this causes potentially a real chilling effect on how the decisions the prosecutor makes, how they exercise their discretion, and what we heard here is that it could have that same chilling effect on decisions that defenders make. What the executive branch is doing is trying to withdraw that discretion and the strategic decisions that defenders make in doing their job. And let me show you in one case how that can have tremendous, tremendous damaging effects on the lives of people. And I want to get back and make one point about, I think that referred to something Lisa said earlier. When I was on the federal district court, there was a case brought under a federal statute, 18 U.S.C. section 922G, felon in possession of a weapon or ammunition. And people will say to me, yeah, we need that statute to get at drug dealers and gang people and all these kind of folks. And that sounds right, Justin, that you need that. But prosecutors also need discretion within that statute. But Congress has said, no, we're going to impose a mandatory minimum. And so here comes a man in Memphis, Tennessee, who is, as Lisa said, he's got mental health issues, and we shouldn't use jails and prisons to deal with all these mandatory all these mental health issues. So Mr. Basir is living at home with his family, and he's taking his meds, but then he gets off of those meds, and he goes out on what I will call, Barry, a liquor crack holiday. He's living on the streets, he's living it up. And he's drinking liquor and smoking crack and doing things that people do. And people with mental health issues are going to be in and out of the system. And so there comes a time, about 6 days in, when Mr. Basir becomes concerned about the public. And he calls the police helpline and says, help, I've been doing what I've been doing, and I've been off of my meds, and I need to get to the hospital because I'm afraid if I don't, I could hurt someone. What a responsible thing for somebody to do who's in that situation. And the police officers say, okay, give us your location and we will come and get you. And they do. But when they get there, Mr. Basir has a little bag of things he's collected during his vacation. And the police tell him, you gotta give us that bag so we can check it to make sure there's nothing in there to hurt you, us, or the people at the hospital. And so he hands it over, consensually. And the police do an intake right there on the hood of the squad car. They dump the bag, and in that bag, there is 145 caliber bullet. There is no weapon, but there's a bullet. And so they take Mr. Basir to the hospital, he is admitted, and they take the bullet first to the state prosecutor where it's rejected, and they take it then to the federal prosecutors where it is received. And they eventually take that to a grand jury, and the grand jury returns an indictment under that statute. And Congress, in its wisdom, has said that when people come in and they've had 2 prior felonies, and this is a third, that it triggers a mandatory minimum under that statute. And so the prosecutors, in this instance, who had no judgment once the case is indicted, but they do have a lot of discretion on the front end, but they receive it and they get the indictment, and they offer Mr. Basir a minimum of 15 years, that's the deal, no parole. And he says, that's too much time. And he goes to trial. And the prosecutors get a conviction. And it's up to me to sentence. And I thought, like Mr. Basir, that's too much time. But the judge doesn't have a lot of discretion, but federal judges don't have to run for election, and I wanted to test this, because I really thought, my clerks and I did a lot of research trying to see what we could do, and it's not a lot, and so I just thought, okay, I will do the judicially responsible thing. I will impose an illegal sentence because the government would immediately appeal it. And then I could get somebody to take a look at this ridiculous thing. And so I imposed a long sentence of 6 years. And the government immediately filed a notice of appeal, and I thought, okay, it's working like I thought it would work. But before the appeal could even get briefed, I got a notice from the Bureau of Prisons that Mr. Basir was dead. And I don't know the cause. So why do I tell you that long story and use all this time? Because when we require prosecutors under the chill of, if you don't go for long sentences and charge the highest crime, you could lose your job. Some prosecutors are not going to take the position that these prosecutors have taken. They're not going to fight back because they have a family that they need to look to. And I'm not talking about, it can happen to anybody, but the people who are most vulnerable, and I'm finishing up, Steve, are the people who are challenged economically, socially, and those are the people at risk. Because the system, they need an independent defender, and they need a principled and independent prosecutor to look at these situations and do justice do justice. That's what needs to happen. So what we're talking about here with these individual people, we're talking about a system that's being put to the test. Remember it was said that we're giving you a democracy if you can keep it. And we see things right now slipping. And it's not just these prosecutors and defenders who have to be concerned, but it's judges and every other stakeholder in the system. Because I'm telling you, people in communities, especially communities of color, are very suspicious of justice outcomes because they see disparities and they lack confidence. And that's the risk for judges and prosecutors and defenders. And now you can talk about the Georgia thing if you want.
Judge, that was a lot better than what I asked you to do. It does cause me to offer one comment, and that is, if you look around the entire ABA, you will find there are almost no federal court of appeals judges who are active, who come and take part, who are willing to get down and do the nitty-gritty work. And Judge Donald does that for us. I mean, she's a blessing for this section. So as far as I'm concerned, she can talk about anything she wants. Nonetheless, I'm going to try again with Judge Butcher, who I should mention, by the way, Sidney was some of you know, a former prosecutor, did defense work in private practice. He's now chair-elect of the criminal justice section, and he sits on the bench in Maryland. I did ask him, because it was interesting, to take a look at what Texas has done in recent legislation. And just to do it, not to go through comprehensively, but he mentioned there were some surprises in that legislation. So Judge Butcher.
Yeah, thank you, Professor. So House Bill 17 passed the Texas legislature in May of 2023. And there were two sections that Professor asked me to look at and share with you. And the first one, I just want to read some of the verbiage, because as all lawyers, we like to know what the language actually says. And some of the panelists have talked about, the word discretion. A lot of the articles that were highlighting this House bill specifically highlighted that this was eradicating the discretion power of locally elected prosecutors, right? So what does the language actually say? In section 1, when it defines official misconduct, that means the intentional unlawful behavior relating to official duties by an officer entrusted with the administration of justice. But what does that mean? So it breaks it down a little bit more. A prosecuting attorney's adoption or enforcement of a policy of refusing to prosecute a class or type of criminal offense under the state law, or instructing law enforcement to refuse to arrest individuals suspected of committing a class, a type of offense under state law. And then they have a couple of different exceptions. I'm going to come back to it in a minute. The second part of that, the second section of that bill provides a defense. And the defense that they talk about, in certain cases, it is a defense in an action alleging a prosecuting attorney committed official misconduct described in this section, that the prosecuting attorney took action immediately on discovering an attorney employed by or otherwise under the direction or control of the prosecuting attorney was acting as described by this section. And so it's interesting with those two parts, and I'm sure what we continue to hear is that with this Texas bill, it's essentially saying that one, when you're running for office and you're coming up with ideas or things of that nature, that now you have to check whether those policies are in line and really move forward with whatever they're asking. You're almost kind of like a robot. So they're really questioning your ability to come up with innovative ideas or things of that nature. You have to also look within your office, because if you have an employee that's prosecuted that may not like your direction or some of the ideas that you've implemented, they have the opportunity that they now need to alert someone. Or even if they do like it, they're told that they need to, if they want to be able to use that defense, they need to immediately say something. The other part that I thought was interesting that's not in those first two sections is that if there is a complaint and there's a hearing, that hearing is to take place by a judge in a neighboring jurisdiction. So it's not even within that same county. It has to be by a different judge in a neighboring jurisdiction. So those were three of the things that I thought were pretty interesting. That's going back to getting away from what kind of Governor DeSantis has said that you had highlighted, where now they're actually putting that language in place.
Yeah, in Texas, I just want to, is an interesting law too, because of the citizens being allowed to make complaints about discretion. And Texas went into effect September 1. And so immediately 12 days later, in Hayes County, the Hayes County Clerk of Court files a complaint against the elected district attorney because of making these, promises during his campaign about, not prosecuting low-level drug possession offenses and things of that nature. Now, nobody had explained to the clerk before he filed that there's a thing called ex post facto laws, and you can't try to file a complaint against somebody for something that happened before the law was passed. So he then withdrew the complaint, but I think it'll spread.
The interesting thing about the citizen part in there is that they only have to be a resident of that jurisdiction, of that county, for 6 months.
Yeah. Yeah.
So it's actually kind of interesting because this wasn't necessarily the criminal part, but if you looked at the education, the banning of books that has happened in a lot of places, this mirrors some of the same wording or verbiage that has been in there that has allowed parents or citizens of that community to file a complaint about a book.
So Sarah, tell us just briefly about Georgia, what Georgia has done.
Yeah, sure, and I think Judge Donald understood the assignment. But in Georgia, what's happening, they've also passed a law that also allows citizens to question charging decisions. But in May of this year, Governor Brian Kemp passed what had been proposed Senate Bill 92, which created some new obligations for prosecutors to individually review every case. There was a question as to whether that meant the elected district attorney needs to actually individually review each case in his or her office, which would be absurd. But it also, in addition to creating this new duty, it created a prosecuting attorney's qualification commission, which would be comprised of politically appointed individuals who are then tasked with investigating prosecutors for various lapses in duty and added misconduct, and added this new sort of category of misconduct that vaguely is conduct prejudicial to the administration of justice, which brings the office into disrepute. So whatever that means, if anybody can tell me what prejudices the administration of justice to bring the office into disrepute, and the willful and persistent failure to carry out the statutory duties of a district attorney. So presumably, then of course these attacking any sort of presumptive non-prosecution policy or a categorical non-prosecution policy that an elected district attorney may implement in order to allocate resources in his or her office in a way that he or she has deemed best and was mandated electorally by the community, the promises that they campaigned on. What's very scary about this is, and right now the Prosecuting Attorney Qualifications Commission is tasked with coming up with what procedures they're going to use to investigate and then potentially suspend or remove these prosecutors. But if they do remove a prosecutor, that prosecutor is disqualified from office for 10 years. So they can't even run again. there hasn't been an investigation yet. The law is new into this bill. There's been a challenge by a number of district attorneys in Georgia to the implementation of this bill. There's an effort to try to enjoin it from going into effect because of the vagueness of what it's trying to do. The judge in that case in Fulton County rejected that effort, and currently the folks prosecuting that case were to file a second amended complaint this week. So we will see, what ultimately happens with that. It's still so much in flux, and so many of these efforts, and you mentioned Florida is in some sense a unique case, in another sense not, because there was a constitutional provision that the governor is using. But in other places around the country, there have been so many different legislative efforts. I was surprised when I was doing some work on this issue to learn that as of March of this year, there had been 37 bills introduced in 17 states that seek to limit the discretion of prosecutors, or they are punitive measures directed at specific prosecutors, or the third form that this is taking is superseding local discretion by transferring the work of local district attorney's offices to the state AG's offices, where the state AG is more politically aligned with the statewide officials. So this tension between the local communities and statewide officials is happening all around the country, and it's moving very, very quickly with sort of indeterminate effects. And there have been a lot of groups and studies, trying to even get their arms around this issue. The Association of Prosecuting Attorneys is looking at this. The National District Attorneys Association, Fair and Just Prosecution, has been studying this issue, and the Public Rights Project. And everybody is trying to work to get their arms around, well, how do we best address all of these different permutations and measures that are happening and taking place. And so I think it's wonderful to have these conversations here today about how can we, come together and start speaking with a unified voice to, as Judge Donald said, as Keisha said, as Ruby said, as everyone has said on this panel, educate the public about what the role of prosecutors and defenders are in the criminal justice system. Because the reason these efforts are successful, I think, is a lack of engagement and a lack of knowledge about, what the role these folks play in the system are. So.
Can I just jump in really quickly in what's happening in Pennsylvania after they failed to impeach Larry Krasner? What's happening for our clients on a day-to-day basis is that we are seeing him step back and start to come back from the expansive reform policies and practices that he came into office with. And I've known Larry for 21 years, so he's a personal friend, and I can have frank conversations with him. But what he says to the media in the efforts about reform and youth practice and diversion, and how we're handling the gun crisis in Philadelphia at the moment is very different from what we are seeing in the day-to-day in every courtroom in the city of Philadelphia. And he's continually being pushed because of the narrative because, as prosecutor, he's responsible for the rise in crime, and there are statistics, there is absolutely no support for that, but the public pressure, which comes not just from city officials on him right now, but also from the state legislature, which is trying to legislate taking the prosecution of certain crimes from him, and narrow his power, and narrow his ability to really expand a lot of the programs that he wants to expand, and in some cases he's now starting to shrink a lot of the programs that he's put in place. So just wanted to provide a little perspective
So
on Philly.
even though the impeachment was unsuccessful, they achieved a measure of their objectives. As you said, they chilled, and so it's changed. So it's
That's
that's what's happening all over.
before I got on the bench, I enjoyed not just practicing law, but being able to work with my friends that were trying to run for office, whether it was to be on the defense side or whether it was to be a state's attorney, having those ideas that they wanted to kind of change the system or affect change in some type of way. And what you're seeing is it's muting it. And it's kind of interesting.
So, we've seen attacks on prosecutors, we've seen attacks on defenders. So you think the judges are immune? I guess federal judges are, Judge Donald, but what about state court judges? Is there going to be attempts now to recall state court judges, remove them, because people don't like their decisions? I mean, what do you, I ask our judges first, what do you think about that?
I think absolutely there were, before, several, I guess more than a decade ago, we had these suits that were being filed in various communities against judges who issued opinions that folks didn't like, and, the judges would have to go through, in some instances, the expense of having to defend these things. Judges have some immunity, but if you're an elected judge, that doesn't really matter. If you go through a nasty fight and people plaster these things all over, then there's a risk of the judge being able to successfully retain that office. But even so, there are people in the community who will make threats and just come after judges in a way that will have a chilling effect. And I'll tell you one other thing, and federal judges don't worry about elections. But even in the federal system, there is a case that I personally am aware of a judge who sought to be elevated from the trial bench rather to the appellate bench. And it was during a time where the White House counsel viewed that judge's record and said basically, you're not tough enough, on crime and sentencing. And there was a discernible difference after that in the judge's sentencing patterns. And later on, that judge was able to move to an appellate bench, but there was, you can see from the time of that initial application, a demonstrable change in sentencing patterns to, tougher sentencing. So I think that these risks they're not isolated to any particular bench. There's a as you say, a discernible effect on actions across the spectrum, potentially.
It's true, isn't it, Judge Donald, that some of your colleagues on the federal bench were trying to push a resolution that would have said it was unethical for judges, federal judges, to participate in certain organizations like the American Bar Association?
Absolutely, and when he says judges, he's not talking about the Sixth Circuit, he's talking about judges, across the spectrum. Yes, there was, but people, it was only organizations that were, quote, progressive or liberal. There was not that same caution against judges, against organizations that were viewed as conservative. So even then, you were trying to make sure that judges moved in a certain direction along the political spectrum. And there was the ABA, fortunately, was one to fight back against that. And many judges still, though, are reluctant to participate in certain organizations that have the label liberal or progressive. So, as you said, we don't have any participating here.
So, Andrew, I want to ask you a question. Like a lot of people.
Excuse me. See, I just have to say this one thing. For the young people in the room, even though in the American Bar Association, in the past, Antonin Scalia led an ABA section.
So, Andrew, I wanted to ask this question. I know other people have asked you before, and some people sitting down here are probably thinking about it. Knowing what you now know, would you do it again?
Knowing what I now know, would I exercise my constitutional rights to speak out on issues of public concern? Would I, as an elected official, do what the Supreme Court has described as an even higher, justification for speaking out on issues? Would I stand up for what I believe in for fear of having the governor of the third largest state in Florida break state and federal law to suspend me for political reasons? Yeah, I think I'd fucking do it.
Monique, what about you?
Absolutely, without hesitation.
You hear what she said? Absolutely without hesitation. Tisha, would you follow that amicus brief again?
It was a humbling moment at 43 years old to call your mother to ask for help paying the mortgage. But fuck yes.
Rosemary, you've talked about this already. If this pattern continues, these attacks on prosecutors, attacks on defenders, attacks on judges, what kind of confidence are ordinary people going to have in the criminal legal system?
I think it's pretty fair to say that people won't. I think the movement here that's going on is designed, I think, to already create that kind of, I think, suspicion or, I mean, that we see this all over the place, right? Like, it's not just within this frame about kind of suspicion of these institutions, of these leaders, questioning what they're doing. So I think it's an ongoing challenge, not just within the criminal justice system, not just with reformed prosecutors and public defenders, but also across all of our institutions. And so I think it's part of that bigger picture.
Tina, I have a question for you, and that is, I had planned to have questions and answers so the audience, so everybody here could have a chance to participate. But I know we're filming this, and I think I have to say that the moderator of this panel was not smart enough to request a microphone that we could walk around with. But can we give it a shot that people can ask a question? I'll repeat it if I think the whole room didn't hear it. So what I'd like to do is open the floor for questions. You can direct it to the panel as a whole, particular people on the panel. What I would ask, though, is this, that we want to have questions, not speeches. And if you keep them short, we'll ask the panel to keep them short so we can have as many people participate as we possibly can. So the floor is now open, and I'll point. If I don't know everybody's name, but I see Ron, you go first, second.
I was just trying to figure out what would happen if you followed the rules set forth in, for example, Texas, or what the governor wants you to do in Florida. If you were prosecuting every case and legal aid defended every case, what would happen to the system? I mean, even assuming you did what they wanted you to do, what would happen to the entire criminal justice, criminal legal system, however you want to call it?
Could you hear him? All right in the back? Okay, then who wants to take a shot at that?
I'll start
I'll repeat the
real
question.
quickly.
If the question was, what happens if you prosecuted every case and defended every case that came to the system? What would happen to the system?
But let's be clear, this isn't about the system, this is politics. Right? So in Florida, if they said you need to prosecute every case to the fullest extent of the law, that would be violating other laws in Florida that said you have to set up diversion programs, you have to consider these things, so the laws would be in conflict. But we know that that's not what they really want, because it's not like they're suspending prosecutors for not prosecuting adultery cases, which are still on the books in Florida. This is just a convenient excuse to go after the people that they disagree with philosophically. So the practical implications, yeah, we can talk about in this room because they may come up in the academic context, but in reality, people are going to continue doing what they want to do so long as it's consistent with what the governor wants them to do.
Go ahead.
Yeah, so first of all, thank you all, and Sarah, thank you to you and the firm for stepping up. And in part, I want to build off of that and also have Andrew maybe chime in as well, because there are a lot of lawyers in the room who work in big firms. And as the executive director of Fair and Just Prosecution, we are often begging firms to engage, and many won't step up. And so I think in some ways what you all have presented is a call to action. You know, that if we are going to stand up for democracy, and this is about politics, this is about preserving democracy, because today they come for one group and tomorrow it's a different one. You know, what would you like to see the ABA do? What would you like to see the law firms in this room do to stand behind Monique and Andrew and the 70 other elected prosecutors we work with in Texas and elsewhere, who are also just very fearful because they have great affection for Monique and Andrew and they see what's happening. You know, what should people leave this room and be willing to do, or what would we need them to do?
So the question is, we have with us the executive director of Fair and Just Prosecution, who has thanked Sarah for the work that she's done and has asked the question, what should the ABA be doing to address these problems, to stick, not just to stand up for Monique and Andrew, but for other prosecutors and defenders who are under attack?
Well, thank you, Miriam, for that question. You know, I think there's a couple things that come to mind, you know, and I think we really need lawyers, everybody to take back to your communities how important it is for the lawyers to stand up for this issue, and for lawyers in private firms to get involved and be willing to take cases on behalf of prosecutors and defenders who are now going to get complaints brought against them. They're going to get sued for doing their jobs. And if lawyers don't think this is important, I don't know who else in society is going to think the rule of law is important. And we absolutely need the ABA and one of the things that folks have been working on is to put together a statement and a resolution and a task force and get people engaged, because the ABA's mission is to advance the rule of law, and this is a rule of law issue. And we need statements that we can point to in these cases to say, this is why this is a problem, number one, and number two, this is why, you know, these prosecutors, these defenders, they are doing their jobs. There are ABA standards that talk about the duty of a prosecutor to reform the criminal justice system and stand up against injustice, because a prosecutor's duty is to seek justice. And so when we are saying that if I think the way you're trying to seek justice is wrong, that you are now neglecting your duty, you're incompetent, you're not doing your job, who is going to be left to stand up to that injustice? And so we absolutely need the public education and the force of the ABA behind this issue. So I urge everyone to talk to your friends and get them and try to get them involved and be willing to take these cases.
Ellen?
Thank you, Sarah. Lawyers are leaders, and it's really important that we're going to have this task force, and we'll file amicus briefs, and we'll engage in public education. There are other organizations doing this as well that are grassroots. So I just want to point out, like the Vera Institute for Justice has convened many different organizations to come together to talk about what kinds of grassroots efforts we can engage in. And Public Rights Project is part of that, as well as other lawyers. So Rosemary, I want to ask you about broader educational efforts that we can engage in that would be helpful, because we've got to get out to communities so that they understand, as Judge Donnell says, justice, as Andrew says, law is only as good as that which is enforced.
Yeah, thank you, Ellen, and I think that is really important to think about and to talk about in this room and also externally. Lawyers and courts and cases are great, but as even Andrew's situation shows, you can win in federal court, and still, if you have basically a governor who's not going to respect the law, functionally, it doesn't really matter what happens, unfortunately. And so I think that there's going to need to be a lot more engagement in not just public education from a legal perspective, but public education from a countering the narrative that, like the Bill Barr brief, I keep referring to it, the Bill Barr narrative, but it is the Bill Barr, kind of wrote on that when he was the Attorney General as well, that the idea that these reform policies is making us less safe, that they are not true justice, that they are not pursuing justice, that they are lawless. Those are all things that we need to be combating both, I think, within the legal frame and also publicly through messaging, through communications, maybe allying with advocacy groups and others, because it is both a legal problem and also a public safety comprehension, understanding of what's really going on public safety-wise problem. And I think that there are other people in this room, Miriam, Andrew, others who have definitely probably been much more in the thicket of that conversation and that fight and who can speak to ways in which this group and others can be more engaged with that.
Can I just add really quickly, I think something that from the public defender side that we are still trying to understand how to do is how to use media strategically to help change the narrative. And it's something that when I talk about my experience, the support that we were able to get, I was able to make a call to the Philadelphia Inquirer because of relationships that I had, and within an hour of us being fired, there was an article about this, and working with groups, I think ABA working with groups like Zealous, other organizations that are really, media drives so much in the work that we do and can shape narrative when we are actually telling the truth about what's happening on the ground. And the second thing I would love the ABA to help with is the finances. We were fired from Montgomery County. We could not apply as part of the settlement. We ended up litigating, and when we settled, that we cannot apply to work for any county position, and not that I would, although I would love to just submit an application to say fuck off, but we cannot apply for any job for 10 years in the county. And so you have people like Stephen in Luzerne, you're not only getting fired, you have to then take the cost of litigation. Civil Rights Court did my representation for free, God bless them, but the financial piece of it too, I think the ABA could be helpful with.
I wanted to point out something that I think, Andrew, sorry.
No, I just wanted to follow up very quickly on something that Ruby said. We're talking about the attack on prosecutors and sort of the criminal justice reform. But keep in mind, this is not limited to criminal justice reform. The policies that were cited in my suspension, and ultimately what the court found, this was about abortion, which does not fall under criminal justice reform. In Georgia, the law they passed is because D.A. Willis went after the president. It has nothing to do with criminal justice reform. It's about, they didn't like the fact that there was, in that situation, a Democrat charging the ex-Republican president with having committed a crime. So it's not just reform, this is politically driven, much more than it is legal philosophically driven.
I wanted to note one thing, and then we'll take a couple more questions. And that is, when you have people like Governor DeSantis and others who are attacking prosecutors, and when you have commissioners attacking defenders, there's an irony here that these people are trying their best to destroy the integrity of this criminal system. But the irony is that it's the first time in my memory that we have defenders defending prosecutors and prosecutors defending defenders. I mean, we've talked about this section being the unified voice of criminal justice. Well, let me tell you, it's getting more unified. It didn't used to be this way. When you have prosecutors saying we're going to defend Keisha, and we have defenders saying we're going to defend Andrew and Monique, that's different. I mean, that's everybody saying we're in this together. And you start attacking one element of this, you attack the whole body that makes up criminal justice. And I think there's hope here. There's hope that what's going to grow out of this is more respect all around for the job we all have to do, the judges, the prosecutors, defenders. Everybody's got a job to do. And if you don't fund them all, and you don't treat them all with the same kind of respect, this system just doesn't work. And sorry, it's my soapbox.
Barry had his hand up.
Yeah, Barry.
I would thank, these people are heroes, right? I feel like, oh my God, we got you into such trouble getting innocent people out of jail. And Andrew, you were literally giving a press conference about how the police chief didn't solve homicides, right? And you get this innocent person out, you're holding that press conference, and I don't think it's an accident that DeSantis had that former police chief standing next to him the day they came after you, and you had to do it in front of a bank, right? But I would feel terrible if I didn't say this right now, because of course what you're saying is true. This is different, right? And everybody that's talked about this is political, that is it. Texas, just to put a fine point on it, that statute is very carefully written so that the court, the jurisdictions next door, will sit on the removal and suspension of the prosecutors. And by the way, that's designed because the reformed prosecutors in big cities, it's the people outside that'll hang them, right? And that whole statute, Sydney, that you read is obviously key to abortion, right? So this is different. All right, I don't care. It's fascism, right? And so you've got to think about what you would do if you knew this was coming in the Weimar Republic. There's no question about it. It's getting on the ground with all the people that are fighting against this. And these laws are very, very cleverly written to accomplish these political ends. But I have something good to say that's hopeful. Because we had this dilemma of this prosecutor in Memphis, right? Amy Wyrick, who plainly was not dedicated to the rule of law. Let's just put it that way, right? And I made this decision personally, even though I'm with a nonprofit, right, to say, okay, I'm speaking for myself. I'm not involving the nonprofits or anything else. And we're going to get Steve Mulroy elected in Memphis. And went out and raised money for him because that's a jurisdiction where you can win. And he got elected. He has done a fantastic job. He has been very careful to make sure they did pass a law in Georgia because it is the using attorney generals to come in and usurp the role of the local prosecutor. So I guess he can't do anything, or the Nashville prosecutor can't do anything post-conviction capital cases, right? But they still have maintained their jurisdiction. But the key is to get on the ground now. This is, democracy depends on this. So, reach into your pocket, find the right place politically. Vera and others are making smart moves about that, but this is not kidding around. This is it. So I don't know. I felt, I don't want to, I'm 74, I've seen too much of this, right? I just don't want to think about, I didn't do everything possible now to stop it because it is fascism.
Since that's probably a good place for this panel to end.